Good morning, everyone. Welcome to our third webinar addressing the legal impacts of coronavirus on K-12 schools. We have our regular panel here today, including Shelli Anderson.
Hello.
Nicki Bazer.
Good afternoon, guys.
Dana Fattore Crumley.
Hi, everybody.
And Jennifer Smith.
Hello.
And by popular demand, we also have a special guest with us. I'm guessing many of you have seen Conan O'Brien is broadcasting Conan at home, and well, we have our own Brian Crowley, broadcasting Brian at home. Welcome, Brian.
Hi, everybody. Thank you.
Okay, for some quick housekeeping, if you would like to ask questions, please use the Q&A function on Zoom to do so. During the first half of our webinar, we're going to be addressing questions that we received from you either through the registration process or through our communications with clients over the past week. The second half of the program, we are going to be addressing questions that we're receiving through the Q&A function on Zoom. Note that we are not able to easily respond to questions in the chat function on Zoom, so if possible, please use that Q&A function to ask us questions. And also, please look for us next week at our new time, which will be Thursdays at 12 p.m. We've heard from many of you that this time would be a better fit, and as always, we aim to please, so we will be planning to move forward next week on Thursday at noon. As always, if you find yourself looking for more information or if we're not able to answer any of your questions today, you can always reach out to us for more information. And also, please check out our website at pandemic..com, where you will find all sorts of information, alerts, podcasts, blogs, everything you're looking for right there. Okay, so let's jump in with our first question. So our first question is in relation to actually DCFS. So we've heard some staff are concerned. What do they do if a very young student discloses that they're at home alone or something else that's troubling during a video chat? And they're worried about having to make a DCFS call. And others are worried that possibly this will make families less likely to engage with teachers during this tough time if they were to call DCFS. So Dana, can you talk to us about any thoughts on that question?
Sure. Definitely this is a concern, and we don't want anything that's going to suppress engagement for kids, because we've all been hearing news stories about how important it is to stay connected to them and try to keep those connections going during this time. That being said, there's no suspension of the requirements under ANCRA during this time. Teachers, when they are engaged in remote learning, are still mandated reporters. And if they have information that leads them to believe that a student is in danger, either from abuse or neglect, they need to report that just as they normally would. And we encourage administrators to make a reminder of teachers of that. As far as trying to do that in a way that won't stop participation or make people hesitant to participate, I think it's a good idea to have general guidance to parents. We've worked on some documents that you've sent us about guidance for parents about being in the home, being there, being present, engaging with your child as they're engaging with this platform. So hopefully that will help discourage anyone that feels like they might want to run around the block or go somewhere there's really nowhere to go, but while their children are home alone. We hope that won't happen.
Okay, so our next question relates to teacher evaluations. And Shelli, I know we've been getting a lot of questions about evaluations. So this one is, what do we do about the fact that we will not be assessing students? What implications does that have on evaluations, and particularly the student growth component? And is there any guidance on how people should address that?
Sure. So the joint statement that came out really did address evaluations and where we're at with them. And for probationary teachers, evaluations are likely already completed. So we have kind of that to put aside. With respect to the tenure teacher evaluations, if you already have the student growth metric that you're going to use and all other data has been collected, the guidance from ISBE and certainly our recommendation would be to have the summative conference remotely so you can finish it up and have the rating done. If there's some piece, any piece really, any component of the evaluation that has not yet been completed, unless there's agreement with the teacher, I would say that you then make sure that you just talk to the teacher about the fact that the rating will default to typically proficient, and that you will either take it up again next year or that you'll put them back on cycle as they're supposed to be for the year after. So I would say that with respect to student growth, as well as any component of the evaluations that's not yet complete, to not try to force something through in this really unique circumstance unless there's agreement with the teacher to do that.
So another type of evaluations that we've had a lot of questions about are special education evaluations. So let's talk about that briefly. What is the direction for special education and open initial evaluations and reevaluations during this time? Jen?
Sure. So at this time, the law is a federal law that requires these. And so that's where some of them are simply very difficult or impossible. And there's been a lot of discussion. ISBE guidance is that face-to-face assessment components should not be done until you get back. But the fact of the matter is the authority to waive these federal requirements is not really regulatory. It's not with the state DOE. It's not with the federal DOE. So that's why everyone is struggling and you're hearing different advice. So I guess what we would say is plan A is meet your requirement and do it remotely. And if you can do the evaluation remotely, definitely do that. Plan B is if you can't, and if a face-to-face assessment's required, then I think we rely on ISBE's guidance that's out there so far. We do expect new ISBE guidance on special ed, and I don't know if this component will change, but we, for now, say we're relying on ISBE guidance that face-to-face evaluations must be postponed until school resumes. And we do that. There is discussion about completing evaluations and doing eligibility determinations without that information. I don't think that really gets you anywhere as far as a legal compliance issue, because you're in a box where you're going to violate a law one way or another. Either you're missing critical information that's needed for the eligibility decision, or you miss the timeline. So just forego any thought that you can be completely technically compliant here. In my mind, if you do it without the required information and there's any dispute, it was a worthless meeting and only is going to engender distrust with the parents. So you might as well, one, try to offer the services the parent's seeking during the remote learning time. I mean, you can only offer so much right now anyway. So if it's, hey, my student needs some more case management attention, or there's a related service issue, see if you can accommodate that without finishing the evaluation, and agree that you're going to do it once face-to-face becomes available again. I don't know, Dana, we've both been fielding a lot of these questions. Do you have any other thoughts?
You know, I mean, I don't have a lot. I think you really hit the nail on the head. It's really the concern. There's a greater concern for the kids who have not yet been identified at all. So the reevaluations, you have an IEP in place already, you can continue, but I think your advice of giving those kids that are not yet eligible, you know, talking to the parents about what the concern really is and trying to offer some interim service and then delaying is very sound.
Great. So jumping to another one of our hot topics, Nicki, we've been fielding a lot of questions about virtual Board of Education meetings and what happens with our procedures during those meetings. So one question we got was, is it required for the board to read public comments that are electronically sent to the board during a virtual board meeting?
Sure, and just to keep our eye on the backdrop of this, I think what the Attorney General's office has come out in their guidance is to really stress that what we're trying to do is keep meetings as transparent and open, and to encourage public participation when we can in whatever way we can. And so while it's certainly not required to read public comments that are sent in via email, we think it is a good practice if boards are receiving public comment in that way and they're not creating another avenue for public comment. Absolutely, reading them out loud, I think, is a great way to continue that public participation. Obviously, you can keep in mind that your normal rules, such as they are, can continue to apply. So, you know, if someone sends you 18 pages of comment, you can read them, and then at the 3-minute mark, if that's your typical, or 4-minute mark, you can certainly cut them off. any of your board rules related to decorum, to language, to sort of civility can be also enforced. So you're certainly not required to read an email that is explicit or in any way inappropriate. And I think also, given the circumstances, it would be okay to limit the emails to things that are related to the school district. So if someone, sends you in an email related to their concerns about the park district, unless it has some intersection with the district, the school district, you can use your judgment there. But again, the Attorney General's office gave a variety of different possibilities for public participation. This is definitely one of them, and we've seen boards being very successful with this kind of reading of emails.
Great. Brian, I don't mean to put you on the spot, but I know that you do a lot of work for boards and Open Meetings Act questions. I don't know if you have anything you want to add there.
Yeah, so I agree with Nicki completely regarding reading the emails. I think the governor's order is interesting. What he provides is that we need to make it so available so people can see it. He really didn't get too much into public participation. It does seem, though, that most of our clients are allowing for some sort of public participation, which I think makes a lot of sense. Email seems to be the most efficient. There are some who have done Zoom-type meetings where they've allowed board members to, residents to participate via Zoom, and then we can just mute them after public participation. So that's also a possibility.
Thanks, Brian. Okay, so thinking about RIFs, Shelli, we got the question, can we RIF educational support staff? What do you think?
Well, I think we've gotten this question from a lot of clients in terms of what we have the legal ability to do, and not that anyone is looking toward that as the answer, but obviously when we look at the budget constraints that we're going to have this year with the change in funding for next year potentially, the question has come up. And I'll tell you that while it's not explicit in the joint statement that you can actually RIF support staff right now, based on the directive that all, you have to pay as if people were normally working, I would say that if there is a need that you have that you're going to say that next year you're not going to be able to have a certain number of people, maybe you have extra aides than you ordinarily would have, you can RIF for next year. I would not recommend, without talking to your union right now, taking action to dismiss support staff this year. So under the school code, you typically have 30 days before the effective date to RIF, which is different than teachers, which usually speaks to the end of the school year. But I would certainly be mindful of not taking that action now without having a plan in place for what that's going to look like and how the union's going to react to that potentially, and filing something with ISBE related to that based on the directive that came from ISBE related to continuing pay until school closure. Now, I'll say that this is all right now only through April 30th, because every rule that we have that's come out talks about kind of till the end of school closure. And while I think we all can expect that it's likely going to be beyond April 30th, at least for right now, that's the end date that we're giving guidance related to. It could change after that.
Now, Nicki, we've had a question a few times now about stipends. Tell us again, what's the latest and greatest on whether or not we need to keep paying stipends?
Yeah, absolutely, Jackie. So we do have to keep paying stipends. And as Shelli just mentioned, the guidance that we have from ISBE on this, the joint guidance, these rules are in effect through the end of the school closure, which at this point is April 30th. As Shelli said, we are likely to see a continuation of school closure. We don't know what the rules will look like following that. At this point, though, we do need to continue to pay our stipends through that time period.
Jackie, that we just did, we were talking briefly before we got started about things about, pitfalls that can happen here. And I think that, Dana had referenced something that she was looking into with respect to, someone getting a stipend and getting paid for that and then still going to the unemployment office related to that. So I would certainly, tell districts to be cautious about that, to make sure that your employees understand that if you are paying them for the work that they're not even being expected to perform, that if they were then to go to the unemployment office to seek more compensation for that, that you would then be, doing everything you could to contest that claim.
Yeah, and the other piece of this that we talked about last time that I think is still important to keep in mind is that while there are going to be some stipends for things that you just can't, the work is just not continuing, people riding on buses and that sort of thing, there's a lot of stipends for activities that we can ask those folks who are getting the stipends to continue to engage with students. So again, I think I mentioned last time, if you have a coach, an athletic coach, posting daily workouts or connecting with their players, if you have a chess club supervisor, putting up a daily, I'm not a chess person, but putting up sort of a daily activity or a daily puzzle for chess folks, and the like. So, an art club doing having folks share their creations. I think there's a lot that can be done creatively here. So you are paying them, and ISBE has been clear that you're paying them and they should be continuing that work. So to the extent they're able to, I would encourage creative thinking around stipends.
Okay, and speaking of creative thinking, we've been hearing a lot in the special ed realm about service minutes. So Jen, are all related service minutes required to be met during this time? So the question we got was, they have a 90 minutes of speech per week in both group and individual sessions, but are difficult to engage through telehealth due to functional ability or lack of internet. Do we need to provide all the minutes, or is it a matter of documentation and that they're doing their best to provide services?
Well, much like how I answered the first question about evaluations, I'm going to start with saying there hasn't been any relief in what the legal requirements are. So the question becomes one of, plan A would be to still provide all related service minutes that are in IEPs. Or plan A is also, if you're going to change those service minutes, to do it through the approved process, which is either an amendment or an IEP meeting. Now, I say that's plan A because I realize, and I've been talking to many different districts, that might not be remotely feasible. Doing amendments might not be feasible or feel feasible, and certainly doing IEP meetings for every single one of your students that you're changing minutes, it might be totally off the table right now. So I think we are in a triage, and it depends where your district is and what you're able to do. So yes, provide the minutes and be creative, like Nicki said, with extracurriculars. If you can't provide the minutes, consider whether you want to do something like a remote learning plan that you formalize through an IEP amendment. I talked to one district this week that I thought was very forward looking. They're starting to, as they do annual reviews or have conversations, do a remote learning plan as part of a component of an IEP in the additional note section. So if we go in and out of these closures for the next 18 months, as some are saying, we start to get to a place where we know for the individual student what that means as far as service, and we're not scrambling. I think as this stretches into a marathon and not a sprint, that's a very good idea. So then we're not in a situation where we're always violating the IEP. Now I've talked to others where it's not feasible, and we know there's going to be some calculation probably of compensatory ed at the end of this, and so we're going to do our best, and that's not the end of the world. That's just the reality. So if we can't meet it, rather than think about it in terms of we're violating the law, it's how do we think about compensatory ed once we're able to serve again.
All right, Shelli, we've had a question that we've been struggling with for a while now. What happens to days of school closure before March 17th? What do we have to make those days up? Where are we with that question?
Well, I'll tell you where we are is that we don't know yet. We are hopeful for guidance from ISBE soon. There was some guidance that had come out before the last revision that was done that talked about days before March 17th. So for those schools that closed on the 15th or 16th, that also had before the Act of God days were imposed, what those days counted as. And you would think that they would count as emergency days, which means that by their nature, they have to be made up at the end of the school year. There was some guidance that had come out from ISBE that could be read as indicating that they did not have to be made up in this instance. Now, if you look at the new guidance, that language has come out. We've actually reached out to ISBE to try to get some clarification around that for the districts that we do work with who closed on the 16th. And the answer is right now, we just don't know what the answer is going to be with respect to whether or not that day has to be made up at the end of the year or not, or those 2 days, depending upon when they close. But we'll certainly, keep everyone abreast of that as soon as we get the answer.
Great. Now, what about, we're now out of Act of God days, we are in remote learning days, and we now have two types of plans that are at issue. We have e-learning plans and we have remote learning plans. Nikki, do approved e-learning plans, those that were already approved, do they have to comply with the new ISBE requirements for remote learning plans?
Yes, actually, we just got clarification of this from ISBE in their newest guidance. So originally, the thought was that if you had gotten an e-learning plan approved in September, that was all that you needed to meet. And now ISBE has made clear that you also need to meet the prongs within the new rules that they've issued related to remote learning plans. So I think the expectation is that most e-learning plans will meet all of the bullets. The one that I think folks may not have originally included, given that the e-learning plans were really just supposed to be for 5 days, or how to transition back to on-site learning, and that is a requirement under the rules for remote learning plans. So I think what districts should do who had those approved learning plans, e-learning plans, is just take a look at the requirements for remote learning, make sure that your plans are hitting all of those, and if not, you can certainly revise or update your plan to reflect all of those components.
Now, what about the bargaining obligations related to remote learning plans? Shelli, can you tell us about that?
Sure. So the guidance that came out from ISBE talked about making sure that you're working with the unions related to the work that's being performed under the remote learning plan. And I think that's really has gotten some clients confused as exactly what they need to do. So for those districts that had put together an e-learning plan before or a remote learning plan now, that only needs to be approved by the superintendent. So the remote learning plan gets approved by the superintendent. The work that's performed related to that plan, to the extent that it affects the working conditions of whether it's your teachers or your support staff, that part of it, that impact on them, likely does need to be bargained with them and worked through with the union. Now, I will say that in virtually every district that I've worked with on this in the last few days, reading a lot of memorandums of understanding, there really is a collaborative effort around this and people really wanting to work together to do what's best for kids and meet the needs of students. So it's really nice to see that, but the idea that the union and district would have to agree on the actual plan itself, that is not required. It's what the work is under the plan that needs to be bargained with the union. But as I said, this seems to have been a somewhat seamless process with most of the districts that I've been working with, and the teachers being really invested in making sure that students are getting whatever continuity of education that they can get and the support that they need during this really unique time. Nikki, I don't know if you've had any different experiences with that.
No, I actually was just going to say the same thing, and not just the teacher unions, but the support staff unions too. Yeah. I think it's been a really nice collaborative effort in most districts, really trying to pull together, making sure that staff and employees and teachers and everybody in the district is supported, that they're participating in this plan, and that the district is moving forward together. So we have not seen a lot of contentiousness. I'm sure it will happen from time to time on certain issues, but for the most part, we see real collaborative efforts.
Jackie, before we move on though, I did notice in our question and answer, and it's probably is a good time for me to raise it, there were a few questions that came up related to what do you do if a staff member is not engaging with students under the plan or is not doing what they're supposed to be doing. And another question related to what if there has to be a check-in by the teacher every day and that they have not been checking in, whether it's on Zoom or some other remote platform. And I would say that for whatever administrator is asking this, the first thing you should do is make sure you follow up with union leadership to follow up with that staff member as to what's happening that they're not doing this. Because as we indicated before, ISBE has said that we do have to continue pay, and the remote learning has to have already started as of the 31st, but that means that we can expect work from teachers and from all other staff. And what we can expect now is likely rolled into what that remote learning plan is. So a teacher cannot decide that they're not going to participate in the plan or that they're not going to do the work under the plan. So really working with the union leadership back to that staff member who's not participating to find out why they're refusing to work. And if you have to take disciplinary action for insubordination, it's certainly hopeful that you would not, that you would work out something before that or find out what's going on. But that could be a likely result if you've got somebody who's just refusing.
So one of the key elements of these remote learning plans is obviously virtual education, and we clearly have embraced that here at Franczek with using these video webinars, and we know that many schools are using Zoom and Google Hangouts and other services of that sort to connect with students. I'll say that if you haven't seen it already, Nicki and I just put out an alert this week that it dealt with that question with respect to just your general population. But we did receive a question of whether or not there are any additional concerns about consent for one-to-one related services when they are done by Zoom or Google Hangouts. So Dana, can you talk to us about that?
Yes, we've received a lot of questions, comments about this. You know, teachers being very hesitant to perform the one-to-one related service via Zoom or via Google Hangout, just because it's different. You're going into somebody's home. The home is a private setting. It's not the same as doing it in the office, which happens to be in the same row of offices as, you know, for other related service professionals, with the windows in the door and everything all set up so you feel comfortable. So I think there's two approaches to this, and I think the guidance that you and Nicki drafted and put up on as an alert on our website is instructive. I think one approach, and the most conservative approach, is just to get parent consent, to draft a consent form, and you know, we can help with that. We have models that we've already done, and email that out to parents and have them consent to the service and explain how the service is going to be delivered. You know, we've had a lot of clients that are very, again, going back to that concern about how do we get people engaged, and we don't want to do anything to stifle engagement or to prevent people from fully engaging, and we're worried about sending out a consent. We're not going to get it back. We won't be able to start services. What about these kids? So we've also worked out, Jennifer and I have been in communication with this with Nicki and Jackie, on a more passive consent that again has some, you know, information about how these sessions are going to be run, how, what the privacy concerns are, you know, and that it's going to be offered. And if you have questions, then just call us. So that kind of consent, if people don't need to get back to you, you can start the services and you just deal with the people that have questions as the questions come in.
We just almost had a Zoom bomb from my children. I apologize for that. I was able to ward it off with a locked door. So moving on, still talking about remote learning plans. What should a remote learning plan be for a student who can't access the district's remote learning plan for general students? Jen, what do you think about that?
So I think it depends on why a student cannot access. I mean, obviously we're trying to work and troubleshoot with whatever concerns, whether it's providing a way to access if there's not internet. I know a lot of you are out there working with families trying to get them internet, trying to get them devices if they can't. Are we trying to do printing for, you know, I'm seeing a lot of parents aren't able to print. Can we have packet pickups? So troubleshooting the problem. At the end of the day, if we just cannot get in touch with a parent, we've had no interaction. That's where, you know, are we trying to do phone calls and at least find out if there's any possibility for engagement, and if there's not, it might be the answer is it is not possible for our family in these circumstances. We are not able to engage right now, and that might be the answer, and that's going to be okay. And I think okay to the extent of we don't academically, so we're not withholding credit. You can't hurt a student, so to speak, academically at this time. We're not lowering grades. But it's a constant attempt to keep that some level of engagement.
Now, we've heard a lot out in the world about PPE, personal protective equipment, and we did receive an interesting question about whether or not schools have a legal obligation to provide PPE to their essential employees who come in contact with the community, so food, tech, those types of things. Can schools require those employees to wear PPE, and what if they can't obtain that gear? Dana, what do you think about that?
So I think that let's start with the easy answer first. Is there a legal obligation? There's no legal obligation to provide personal protective equipment to people who work in a school. I mean, obviously, if you've got early childhood programs or you have programs for very disabled students, you may have guidance on terms of students that need to be toileted or students that need to be fed. that you follow, but you know, the law is just not, as we can see, the law is fast, but it's not nearly that fast, and any rules on PPE are not in place right now that apply to schools. As far as requiring, you know, staff to wear certain equipment, certainly you can make requirements for to have staff wear equipment, but again, going back to the final question, where are we going to get this? And we need to be mindful of what we've heard on many news reports and make sure that the equipment is going to hospitals and people who are treating patients, and less just for common exposure. I think what you need to do is go to the CDC website, you know, follow that guidance in terms of hand washing, social distancing, all the guidance that they have for essential workers, and really embed that in what you're doing in your schools.
Great. Now, thinking about, sorry, one second, I got lost. So thinking about discipline, we have been hearing a lot of questions about how do we handle discipline in the virtual classroom? Dana, any thoughts on that?
Well, I'm going to let Jennifer weigh on this too. I mean, I think discipline in the virtual classroom, you have to have, you know, just general classroom maintenance of discipline. And I think, you know, teachers are the front line of defense for that. But as far as other, and I think teachers need to document problems that they have that they can address in the moment. But certainly more district level, school level discipline. You know, Jen, what do you think?
Yeah, I honestly, I haven't gotten too much of a groundswell that this is a huge concern, but can you, for example, prohibit students from being in a Zoom class if they weren't acting appropriately? Sure, absolutely. It's not a right that they can keep being a jerk to their classmates on the computer. Or if there's discussion boards and they're not using appropriate, can we bar them? Yes. Are we going to go to a length of expulsion or, you know, long-term suspension? That seems, there might be a need for, then you're going to think in terms of placement changes, just as we normally would, is a discipline intervention where we actually need a different team of experts working with this student because they're so out of control. I haven't had a student where that's been the need yet, but could we get there? Sure, we could get there. And some alternative schools are providing remote learning, so that's still an option that's out there.
Great. So we're at about halfway through the hour right now. So what we're going to do is we're going to jump ahead to ask Brian a quick question that we had prepared, and then we're going to move on to your questions. If we end up having time, we'll come back and finish up the ones that we'd set aside before. So Brian, thanks again for joining us. And I know you've been working with a number of clients on requests from transportation and food vendors for payments for vendor employees during the shutdown. We've received some questions before the webinar today about those issues, and so we were hoping you could provide us an update with where things are.
Yeah, thanks. Thanks for having me, guys. So this is something that I've been working on since the school closure. This has been my life's project thus far regarding this. And so a number of vendors have been acting aggressively towards our clients, namely bus vendors, some food vendors, and they've been seeking payment for this period of time that we're out of school. And a number of school districts have made the determination that is actually in our best interest. We want to do a stopgap to help these employees. So originally when we thought school was coming back in April, and at the end of April, and now in May, the thought was that these employees won't run off to Amazon, other jobs. They'll stay with the bus company, and then May 1st, when we're starting school again, they'll be there. I think that intent behind that agreement is changing as we see Indiana, Georgia, Michigan, others dropping out. All of a sudden, it's looking more and more likely, although I won't make that prediction, but it's becoming more and more likely that Illinois might be following. And I think if that happens, this issue and the intent of that agreement vastly changes. And so then I think school districts need to ask themselves, does it still make sense to enter into this agreement? And one hypothetical that could clearly happen is September comes around, October comes around, you're in front of your community who's hurting because of this. You have people who are unemployed, and they say, what do you mean you were paying vendors who weren't doing anything for you? Also, just being fiscally responsible at this time, We don't know where property taxes are going to be. With that said, I do think that there's reasons for entering into these agreements still. One, your answer may be, we feel an affinity to these people. We have a partnership with our bus company. Two, we do want to help these employees. We have empathy towards them, and we want to be there for them. I think three, though, where this is going and where I'm seeing some clients headed is that, true, maybe school is going to end this year, but we need that bus company there in the fall. And so what sort of dollars, what sort of payments could we help these bus companies with to make sure that when school does come back around in August, they're there? A second issue to think about why there's merit to these agreements is the CARES Act. So we have noticed in the last week, and this has been an incredibly fluid situation, and for those of you, most people I think are familiar with the CARES Act, but that's the $2 trillion act that the federal government just passed and the president just signed last week that does benefit schools as well, where we'll be getting dollars from them. There's a line in that legislation that says if you, school district, get dollars from the federal government, and you will be getting dollars if you receive Title I-A dollars. And as we've looked at that, that's pretty much every single school district, although that varies depending on your need. But there's a line in there that says, and I'll read it, districts that receive funds must, to the greatest extent practicable, continue to pay employees and contractors during the disruption and the closure. And so bus companies have used that as leverage to go to a number of clients and say, by the way, the CARES Act says you have to pay us. Here's a full bill, 100% bill for the month of March. Here's an 80% bill for the month of March because of the CARES Act. Our reading of that is not that, it certainly does not require full payment. And it appears that the intent is really more for paying for technological infrastructure, helping kids get technology, et cetera, but it is vague. And we'll see as the weeks and months proceed what that means. But in the meantime, if you as a client are getting a bill like that or getting a letter like that, it's imperative that you dispel them of that myth immediately and also reject that bill under the Prompt Payment Act. Now, that's not to say that we shouldn't be working with our contractors, but just be aware that that's out there. And regarding the contract that we prepared for our clients, we provide in there, it says that if we make these extra payments to you, we've complied with our requirements under the CARES Act. So it's a nice extra protection to have. Another reason to think about that agreement. One other issue that I want to emphasize, and Nicki and I have both been working on this with ISBE, is there's concern about the ISBE reimbursement. So as people are listening know, for your transportation costs, you are able to seek reimbursement from ISBE. If it's special education, you typically get a lot more. If it's regular education, it's less, but you get some dollars for that. We have a concern, and we provided in the agreement that if we don't get our reimbursement from ISBE, contractor, we can go back to you and say, give us our money back. That has been met with much consternation by the vendors, saying that, hey, once we get our money from you, we're going to pay our employees, we're going to pay our bills, the money's gone. And we're not going to hear from you, school district, because you're not going to hear about your reimbursement until September, October, November. So it's a real problem. So ISBE has come out with a number of communications now, and including their recent FAQ, that says we will reimburse for your contractual costs related to this. So I believe we have some confidence that ISBE will reimburse. I think the bigger question is how much will they reimburse? And we don't know that. And that's another thing, eyes wide open with these contracts that clients need to think about regarding if we make this kind of lump sum payment, what can we expect to get back from ISBE? And it may not be that much. We just don't know that yet. One final thing, one thing that's been very interesting about this project is about 30 clients have reached out to us. So we've really seen the gamut of reaction to this. And I know a lot of people have asked me, well, what are other people doing? So I would say the range is many clients are just standing back, seeing how this fluid situation moves on and waiting before they enter into an agreement with vendors. There are other clients who are very anxious to enter into these agreements with their vendors. They feel real affinity for those employees and are very concerned about services being shut down. And then third, as I alluded to before, I was on a phone call with probably a number of people who are watching right now, and there's a group of districts that are moving away from that original intent of the contract to help employees right now to, hey, vendors, how can we help you to make sure that you're gonna be open in August? So that's where we are right now. I expect in the next couple of weeks this will continue to be a major issue, and the contractors are all over us on this. So we'll continue to help you on it.
Awesome. Thank you, Brian. We know you've been working hard on this, so it's great to have your insight. And if anybody has any questions for Brian, he's going to stick around for the rest of this Q&A, so just fill them out on the screen. So jumping in.
Jackie, I think there's one question that just came up that I just read for Brian that comes from a good friend of the firm who wants to know what happens if the bus vendors don't pay their employees. So if you pay the vendor, but the vendor doesn't employ employees, do you have any recourse? Does the district have any recourse in that?
Well, it depends if they use our agreement. So our agreement contemplates that. And our agreement basically says, you need to pay your employees. You need to show us proof that you're paying your employees. And if you don't, we're not giving you your money.
Yeah, and there was a second question that came in about asking for certified payrolls. And absolutely, our agreement contemplates getting proof that they're paying their employees consistent with the terms of the agreement. Absolutely, a hugely important thing.
It also looks like there was a question about whether or not the part that is going to be reimbursable by the state is just for salaries, or do we have thoughts that it might go beyond that for other transportation costs?
Yeah, Nikki, help me out here if you know. I mean, my sense of I am not an expert on the reimbursement. My understanding is that you make contractual payments, and that a portion of that is reimbursable. And so long, and the way we've structured this is our agreement is an amendment to the existing transportation agreement. So payments under that would be contractual payments and should be reimbursable. I don't think it's just limited to we paid employees or not.
I think that's right, Brian. And I also wanted to just add, because you were talking about the ISBE Q&A, and I think there's been some information circulating that, there's both the Q&A that ISBE has released that very clearly states that they will reimburse, again, we don't know how much, but there will be some reimbursement for, payments made under contract, regardless of whether the service has been provided. So in this period during closure. But also they have issued an emergency rule that talks about payment for other costs. So if you're using your bus company, for example, for distributing food or some of the other items that might come up where you're using your Wi-Fi, roaming Wi-Fi, that sort of thing. Those are additional reimbursement items. So there's been this sort of chatter about whether or not the emergency rule should have expanded to make clear that that ISBE would reimburse for contractual items that were not being delivered but were still being paid for. Our reading of it, and actually has now been confirmed by ISBE, is that ISBE's position is that the rules already allow for districts to be reimbursed for payments made under contract. And so there was no need to amend the emergency rule to make that clear, that the Q&A is certainly sufficient. That the emergency rule took care of these other previously unreimbursable items just to provide some flexibility. Again, all within the context of, as Brian said, we don't know what this claim is going to look like. We don't know the level of reimbursement that ISBE will be offering. Obviously a lot of that is dependent on how state revenue looks. So complicated issue, but I think we're trying to move forward as best we can with these vendors so that they can pay their employees, we can keep our employees, our bus companies running, but also that we're cognizant of district revenues.
So one last comment on the transportation issue. We got not really a question, just a comment for the enjoyment of the firm. Someone's vendor said they shouldn't be required to produce more records than originally put in the contract. Why wouldn't they want to provide payroll records? So just an interesting comment there from someone's experience in the audience. So switching over to special ed, we did get a question for special education. Do we run the risk of having to provide significant compensatory services during ESY or next year? Jen, do you have thoughts on that?
Yes, I mean, is the answer. Yes, there's a risk to significant compensatory services. We don't, and that's why if you're providing services, I'm advising we want to both track the services that you're providing. I think even if we're not tracking attendance for other things, we want to somehow track student availability for services. So just like during the school year, if a student is absent, we don't provide comp ed for those days. We only provide comp ed when we don't offer the service. So I think that we want to at least be able to preserve data to make the argument that if a student's not available, we don't provide comp ed. We don't know what the calculation is ultimately going to look like, but if we don't have those data pieces, we can't even make the argument. So if you're doing it, track it. If the student's not available, track that. As far as, and then just to say, we don't know the calculation, so it's just important that we leave all options open for a calculation, because there is going to be a capacity issue. You cannot make kids just, okay, you missed this many, you're going to go to school 12 hours a day next year. We don't have the teachers for that. We don't have the, you know, it's not possible to just make up this time. That's not a realistic thing. So there's definitely, this is where a lot of the conversation is happening as far as on the federal level and on the state level. What does comp ed look like at the end of this? We don't know.
So one thing that I would add to that is, I mean, I do think there'll be some comp ed considerations, but you know, there's somebody said something to me earlier the week, solve one problem at a time. And I'm not sure that we're going to have a huge comp ed problem with the majority of our special ed students. We're going to have comp ed problems in the kids that are more significantly impacted by their disabilities. But when you look at big school districts and the majority of their special ed population, that is a resource level population, which means they get served by you know, meeting with a resource teacher periodically, but they're generally accessing the general ed curriculum. I don't think we're going to see big comp ed claims for them, just for the reason that the existing analysis, you know, does take into consideration a comparison with regular ed kids. And while they're suffering some deprivation, the general education students are also going through that same experience. And that is going to be taken into consideration. So I think that will prevent some of those claims in that large segment of the special ed population that receives a more minimal level of service.
Okay, we also got a question that relates to whether or not we have to pay employees who refuse to work. Shelli, do you have thoughts on that?
Yeah, I mean, it goes along with what I was saying a little bit earlier. I mean, I think it really depends on why they're refusing to work and what is the work that you're expecting them to perform. So I've only heard from a few school districts about employees who are refusing to come in, who have been deemed to have to carry out an essential function in the district. And the issue really is the why they're not willing to come in. So for instance, if it is something that they are fearful that they're going to get sick or something along those lines, it's an issue of whether or not you can require them then to take a benefit day if they want to stay home and do not want to come in to do that portion of the essential work. But really, if you don't have that issue, or if they don't have benefit days left, or if there's not any reason that they otherwise have for refusing to perform the work, you can take disciplinary action if you feel that there's no other basis for them not doing the work that's being required of them. And I think that there's, you know, the reality is that what recently came out from ISBE is we've identified very specific groups we know are essential functions, so they're performing essential services, so people in charge of feeding kids, putting together learning materials, our janitorial staff. Everything else is really within the local control to determine if someone needs to come in to perform an essential service. So I think that if it's a union employee, like I said before, speak to union leadership about how to handle it. If it's a non-union employee, you give them the directive that they need to perform this work. And of course, assuring them that if it means that they have to come in, that you're abiding by all of the public health guidelines with respect to distancing and how you're keeping it clean and all of that. And the districts that I know who are still having people come in are really taking some amazing precautions to make sure those employees are safe. And while I understand that it's scary for some people, you know, I would hope that there are not people out there who are just being opportunistic about this, but to realize that it requires communication. And if everyone's talking together about what you're doing to keep things safe, hopefully you can work through those issues of someone refusing to come to work for those reasons.
Now, we know a lot of our board meetings have moved to the virtual realm, but some are still occurring in the physical board location. So we got a question, should we still allow public participation for board meetings by having our boardroom available to the public? Nikki, do you have thoughts on that?
Sure, and I'd love Brian to weigh in as well. I think, again, the advice from and the guidance from the Attorney General's office is to try to provide access to the public in the best way that you can, but that is also consistent with the public health guidance. And so if there's an ability to create a space for the public that allows you to also keep in mind social distancing requirements, then, if the board is meeting in public, that can be provided. But again, if you're unable to do it safely, I think obviously our priority is to keep people healthy and safe. But to the extent that you're able to think creatively about that, certainly do so. Brian, I don't know if you had anything to add on that one.
Yeah, I think we're weighing interpreting the Open Meetings Act and public health, and I think in this, I think people are going to be very sympathetic towards public health. So while we will, if you have a board meeting and 4 are going to be in the room, that's fine. And if people from the public show up, but I believe, and I may be wrong on this, I'm forgetting what the total number of meetings is. It 10 people right now that we're not supposed to have in a room? I mean, we have to adhere to that. And I don't expect much worse for someone to get sick than to have a public access counselor complain.
Absolutely. Well said.
On another open meetings question that Brian, you may have some thoughts on too. We had a question, we are issuing bonds and bond counsel is saying the executive branch did not have the authority to change the rules. They will not certify that the district has fulfilled all the requirements of the Open Meetings Act unless a quorum is present, at least until the legislature has confirmed the new rules. So obviously this is referring to the changes through executive order to allow certain meetings to occur and certain business to be undertaken virtually, but they're getting some pushback. Do you have thoughts on that?
Yeah, I know bond counsel has been very conservative in their analysis. And I don't think it's an unfair analysis on their part. There's nuances here, so for those types of issues, I think it's important for clients to reach out to us directly and talk that through a bit. But for things like bonds, if you can get comfortable with 4 in a room and proper social distancing, you avoid that argument completely. But if there's a discomfort with that, we should work through that with you with your bond counsel.
This is, it's a similar issue. We've talked about this before with, RIFs and non-renewals of probationary teachers. It's the same concern that districts have been talking with us about, did the governor have the authority to suspend certain Open Meeting Act requirements? Again, hopeful that the General Assembly will be able to confirm that action. But in the meantime, there are some legal concerns with that. And as Brian said, if you have something like a RIF or you have a bond issue, definitely talk with us, with your bond counsel, to make sure that we want to make sure that, to the extent able, we're getting those things done in the right way.
Now, we had another special ed question. Jen, maybe you can tell us your thoughts on this. So any thoughts on what might happen if DeVos passes a law in 30 days to waive some of the special ed services for students with disabilities? Do you have any information on what services might potentially be waived, and will that service need to be made up at a later date?
So I know that several advocacy groups for schools are trying to get into the federal. So DeVos cannot she doesn't have authority, I would say, to just waive service requirements. It requires a law change. And I know that there's lobbying happening for this next go around in Congress, the 4th bill, to put in language to give her that authority that she would need. So my understanding, and this gets into politics, is that the Democrats are almost entirely against that. There's been some receptiveness of Republicans to proceed with that kind of language, but it's the parents' lobby has been very, very active, and people are getting flooded with calls. Do not abandon our students. The advocacy group I'm involved in, National School Board Association, we're advocating for a waiver only where the student or staff's health would be impacted for the service to continue. And that's in an attempt to get legislators who aren't comfortable with giving DeVos broad waiver authority. So that would be only face-to-face services. If an IEP requires face-to-face services, those would be waived. My understanding is that even that very limited waivers not getting a large amount of traction. I hope it does, because I think it's a very common sense approach. Like, in the hierarchy of needs, we're not going to put even a student's health. We have medical fragile students. I mean, it makes no sense to put them at risk of getting the virus right now to comply with an IEP. So if that did happen, she did get waiver authority. I think that's the most likely category. And there hasn't, in the proposed legislation, it hasn't been a comp ed issue. Although one one idea I brainstormed with the group was maybe offering to replace face-to-face service with another service that could be done remotely, so parents don't feel like they're missing service. It's a net neutral service. We're just shifting from something that couldn't be done in person to something that can be done remotely. But that's my knowledge so far on the status of that possibility of waivers. I would not rely on it. Like I said, these things move quickly, but my understanding is not getting a lot of traction.
So we've had a lot of questions about substitutes. So one of them is, I can understand paying long-term subs, but random subs are filing unemployment claims. One worked 2 days, so planning to protest. Is that legal? Anybody have thoughts?
Start. I mean, I guess it depends on what they're asking. If this is legal, is it legal that they're, asking for or filing for the unemployment, or that they're protesting it? And I would say that certainly you can protest unemployment or contest the unemployment claim based on the amount that the individual actually worked for you. I know that many districts we work with, a long-term sub, they're handling one way, but day-to-day subs they're handling differently, because they don't have any way to judge how much they would normally have been working had the school been normally functioning. I will say that because of the sub shortage, there are some districts that are making the decision to say, we're going to look back at a certain period and pay them based on the averages for the remainder of the school year, or through April 30th at least, and others who are deciding that they just cannot make that assessment, and that those subs are then going to go apply for unemployment. And they're just making sure that when they respond to the unemployment claim, that they're being specific as to how much that employee actually worked for that school district. So there's not some false narrative there about the amount of time they worked for them versus perhaps another district. I know, Nicki, you've been dealing with this a lot too. Do you have any other thoughts on that?
No, yes. I mean, I think in terms of the unemployment claim, absolutely, that's the advice I'm giving as well. I think you had mentioned the difference with these sort of one-off subs who are maybe in your pool or working intermittently, and your long-term subs. So that we have seen consistently questions about paying long-term subs, and our advice has been that you need to continue to pay long-term subs for the duration of their assignment. And so you would pay them as you would pay your other employees. If you've contracted them through a leave that a teacher has until May 1st, then you would pay them through May 1st. I know that this has raised questions about, because we've had teachers returning from maternity leave early. And again, our advice has been that you would continue to pay both if the teacher wants to come back from leave and they're able to do so, you would pay the teacher certainly, and you would continue to pay that long-term sub through, again, the time that you had contracted for with them originally. So if, again, that leave date was supposed to end on May 1st, you would pay them through May 1st. Again, obviously we understand that you're paying 2 staff members, but you should certainly then utilize your long-term sub to supplement, to help with curriculum. The other piece of the sub question that I think we've talked about before, and another reason to continue to pay those day-to-day subs potentially, is that particularly with our elementary districts who, I know in our high school district, a lot of times you can sort of team up with another teacher and help out, but as our teachers unfortunately will become ill with regular illnesses and God forbid with COVID, we are going to need our substitutes even during this remote learning process. So, keeping those substitutes available to you can be an important resource for a district.
All right, everyone, that is all the time that we have for today. I know that Shelli and Jennifer are going to be heading off to speak to the EdRed group in just 30 minutes, so we want to respect their time as well. Thank you to all of our speakers, and thank you also to everyone in the audience for joining us. If we did not get to your question, we will make it a priority to do so at the top of the hour next week. So again, you'll be seeing us next Thursday at noon. And please send any questions that you'd like us to address either through the registration process, or you can send them directly to allmarketing@franczek.com. You will receive an email at the end of or at some point today that will include a link to this presentation, which you can share widely, and also a survey, which we do take very seriously. So please take a moment and let us know how we did and what else we can do for you in the future. Have a great afternoon. We hope you go out and enjoy this beautiful day, and everyone stay well. We'll see you next week.
Thanks, everyone.
Jackie.
Thanks, everyone.
Bye, everybody.